All right. Is there a motion to open the public meeting of the Holyoke Planning Board?
So moved.
Second.
All in favor?
Roll call vote for Kate.
Yes.
Amy,
Yes.
Rosanna,
Yes, ma'am.
Lauren,
Yep.
and Grinder.
Yes.
Okay, so we're open, and first on our meeting agenda is the special permit to increase the sign size for the Sumo Sushi Hibachi Bar. And I believe we have a draft notice of decision and everything.
Yep. Give me 1 second.
I think that's very smart of them moving that sign because they're hard to find if you don't know they're there.
Yeah.
Can everybody see it?
Yes.
Yes.
It just needs to be advertises and supports.
Yeah.
And I don't think 6 needs to say and quantity, right? Because it's just one.
Where is that? Where are you seeing that?
Number 6, it could just be the proposed sign size.
Oh.
And going back to 4, I say the proposed sign size is appropriate for wayfinding and advertising. Anybody else have any comments?
I'll move that we approve the special permit for an increase in sign size for Sumo Sushi Hibachi Bar.
Thank you. Is
I'll
there a
second that.
All right, all in favor?
Roll call vote for Kate.
Yes.
Amy,
Yes.
Rosanna,
Yes, ma'am.
Lauren,
Yes.
and Grinder.
Yes.
So at this point in the agenda, I am going to suggest, if it works for Jane, that we take items out of order, because the next on our agenda is executive session. It may take us some time, and we do have people here to talk about an amendment to the Agilitas notice of decision and to talk about ESG. And if everyone is amenable, I would say let's get the patient people who've been waiting to talk to us seen to first. Jane, does that work for you?
Yep, that's fine with me.
Okay, in that case, what is up next is the site plan review amendment for Agilitas. And Mary, Craig. Well,
Good
Chris,
evening.
sorry.
Is Mary or Craig here? I'll let them do the intros, just making sure that they're here.
Yep, I'm here. Can you folks hear me?
Yes.
All right. Good evening. I'm Craig. I'm the project manager from Agilitas Energy. Also on the call is Mary Sullivan, our project developer, and Nick Fasendola, the civil engineer of record, who just spoke. Just a brief introduction. So we're here today for two main reasons. Our planning board approval, condition 8, I believe, requests that we come back to the board within 6 months of the issuance of the permit just to provide an update So quick update, we do plan on breaking ground, I'd say within the next 2 to 3 weeks. Just working through everything administratively, but project should be underway. Assuming that everything else is goes smoothly during this meeting. And the second part of that, there's a few just minor changes to the original site plan, which Nick can detail, but just an overview. As you may or may not know, the interconnection provider for this battery system is HG&E. Just so through that coordination, we found out that they have requested a few additional pieces of equipment on site.
Mhm.
So the plan updates just simply show those pieces of equipment. Nick, I'm not sure if there's anything else you'd like to add. But
I mean,
that's-
if the board wishes, I can pull up the plan and go through those changes, or if you've had a chance to review the letter, or if Jeff's had a chance to review the letter and brief the board, it's up to you guys what you'd like to hear.
No, I think that we discussed this in a previous meeting. Either that or we have seen the documents, but I think it doesn't hurt for us to, if you want to just pull it up on the screen and give us one last look at it.
All right. So believe I'm sharing my screen. Can everybody see the plan?
Yeah,
Yep.
there we are.
All right. So two major, well, not even two of the minor changes were they're primarily equipment pad additions. So we have two new small equipment pads up by the roadway here. They're still
Mhm.
on the private property that Agilitas owns now. And they're not in the right of way, but they are within the vicinity of Kelly Way. So those are some new switch gear and utility termination cabinets, as Craig stated, items that HG&E decided that they wanted to have added to the project once they got further in the development phases and knew this thing was coming down the pipeline for construction. Another change is we're showing bollards because these are close to the traveled way. So there'll be those standard yellow utility bollards, concrete filled iron pipes with the yellow plastic casing that you see around transformers, just to protect that equipment and to make sure that in case a car was to jump the curb, they would be protected by those bollards. To make these pads work, we had to do a little bit of site grading because the pads have to sit on level area, and this is a sloped area. So we had to pull our limit of disturbance out down this area here, a couple extra 100 square feet, very minor, to provide and grade out a level area to install these two new pieces of equipment. And then in this area of the site, there's an addition of a new transformer that the utility requested in this area here, and this other secondary equipment pad, another shut-off piece of equipment that the utility requested. In this area, there was only this one pad here. So essentially, we shifted this over a hair, and we're able to squeeze in these two other pieces of equipment. Ground cover through here, it was always going to be crushed stone. Now that's just going to be crushed stone around those pads. We have what we call the SCADA rack here. This is where we have the one site light that's kind of on a motion sensor that we talked about before during the public hearing, and that's where the cameras for the facility will also be mounted. So these pads are all going to be located within the fenced area. These two pads up here are outside of the fenced area. Other than that, everything else remains the same as originally approved, but we wanted to make sure that the planning department and your board had a chance to take a look at these and determine if they were minor or needed a amendment to the issued site plan approval permit.
And just out of curiosity, what are the pieces of equipment for lay people who don't know what they're doing here?
Can't speak to every piece because I'm not an expert in the electrical side. One of them is a switch gear. The other is pretty much a disconnect switch. So essentially, if there were an emergency on site, you would
Yeah.
go directly to that, hit the button per se, and it would shut the system down.
So that's these two up in this area. And this one, I believe they called it a step up transformer. I don't know.
Correct.
You
So
know,
that,
because you're talking different power voltages, I believe. So to make it talk to the proper voltage that the batteries are able to accept, I believe they wanted to have a second one of those here because we also have a second a transformer in this location, if I'm correct.
correct. So
Right.
before it interconnects to the grid, it's like Nick said, pretty much just making apples to apples, essentially.
No, it
Right.
sounds like basically additional safety equipment.
Yeah.
Yep.
And as you all probably know, there's a certain amount of public noise around the safety of these systems. So when people ask, it's nice to be able to say, yeah, they added some extra safety equipment in there. So anybody else have questions, comments, etc.? I see no one. That includes any member of the public who would like to speak at. Well, no, we don't have to hear comment from members of the public, but I would still be willing to. And I don't know how the rest of the board feels about this, but this strikes me as a minor thing that we can just vote to approve tonight without rolling you back in. Does anyone disagree? Okay, then is there a motion to approve the site plan review amendment?
I'll move that we approve the amendments to the site plan review.
Second.
All in favor?
Approval for Kate,
Yes.
Mimi,
Yes.
Rosanna,
Yes, ma'am.
Lauren,
Yes.
and Gurinder.
Yes.
Okay.
All right.
Thank
Well,
you
thank you
for
for your
coming
time. We
in.
appreciate it.
Yeah, thank you very much. Just one quick question. I saw on the agenda, I think we were slated for the 8th as well. I don't know if that's necessary. I don't know if it was a copy over.
That was a typo.
Okay. All right.
Okay.
Just wanted to confirm.
No,
All
I
set.
appreciate that.
Appreciate it. Thank you, folks.
Thank you.
Have a good night.
Okay, so next up is a discussion coming out of the ESG site plan review and addressing notice of decision items 17 and 18. And I think this had to do with subdivision issues.
Yes, and for the record, Tom Bavenzi for the applicant, and I have with me Leon Zeffrin from ESG, my client, and Chris Chamberlain from Berkshire Design Group. And what we're, just by way of background, and you're probably familiar with it, in the site plan review, your condition 17 talked about the need for frontage being shown on an approved and endorsed subdivision plan. And the reason for that came about because of a definition within your zoning bylaw that defines street as being either something that's public or shown on a subdivision plan for purposes of frontage. A previous building commissioner had made a determination back in I think it was probably back in 2018, when the first building was built on this site, that street could include something shown on an approval not required plan. I think there was some level of clarity that was brought to that later, years later, when the site plan review was looked at, and it was determined by the city that it would have to be shown on a full subdivision plan in order to have the definition of frontage for street under the zoning ordinance. There has been, and I have been talking with City Solicitor Mentaleski on this for a period of time, and there have been cases in the Commonwealth that have dealt with this issue when community bylaw or ordinance requires a street to be something shown on a subdivision plan. And I've forwarded on, I think, a couple times the Berg versus Town of Lexington case, which has dealt with that, has dealt with this. And in that case, the planning board had recommended to the applicant that the only way that a street could be shown under their local regulations in Town of Lexington, like is the case here, was to be shown on some subdivision plan. And even though that subdivision plan there was on a paper street, the planning board and the courts agreed that the planning board had the power to request, and the applicant agreed to, and my client is willing to agree to this too, to have any improvements that are needed if necessary to upgrade the private street, which will remain private but be shown on the subdivision plan for purposes of safety, access, utilities. And the court also found that by ownership of a right of way in the private street, and that would be the case for my client in connection with the 28 Water Street property, that included the right to make any improvements needed, as well as install utilities in that private way, and that would suffice for a subdivision. I think in this case, when the first building, which is a power plant, was built in 2018, at the request of various departments, maybe DPW and the city, my client did in fact upgrade significantly the access way over this private street, Water Street, and also installed utilities, and also did other types of improvements. So the road leading to the property today has been significantly improved. I think fire department was involved. I think other departments were involved. As you know, your site plan approval is for an addition at this site, so that would be a second generational area, as well as other site improvements. So what we're here today is just to discuss the mechanisms and what other improvements my client, the applicant, would propose in consultation with different departments in the city in order to obtain a so-called subdivision approval of this. Many communities, as you're well aware, they allow building frontage on an approval not required plan, which technically is a type of plan that the board would make a decision provides safe access over a roadway system. Your ordinance may not allow that, and notwithstanding the previous interpretation of a building department official that was allowed, building permit was issued, building was built, occupancy permit was given for that. For the addition, just to kind of in a level of comfort and provide absolute assurance that we're complying with zoning relative to a frontage, we would propose some type of subdivision plan to your board for its formal approval and endorsement, along with any other needed improvements to that private roadway system. We would point out the case of the Berg case. In that one, there was a private roadway system, and like this one here, that had access to the site. And then Chris Chamberlain is here to discuss these, the specifics of what we would be looking at in connection with the subdivision plan.
Okay, thank you. Jane, did you want to weigh in on at this point? My recollection of this was that we were looking for a subdivision plan just so that we would be technically allowed to say yes to it. And
Right,
this sounds
so, sorry, Mimi.
like, this sounds to me like a subdivision plan, but you are the expert here.
I wouldn't say that. But yes, I have had conversations with Attorney Bavenzi. We have seen a possible draft of a plan. And so I think if if Jeff wants to chime in about the timeline for getting that approved and going forward with that, that would be helpful. But I think that at this point in time, I think the board should be ready to take a look at the subdivision plan, they should be able to submit it so this project can start going forward.
Sounds like great news. So Chris, you want to tell us what you've got?
Sure, I'm happy to. I think this is actually relatively simple, and I am not 100% sure which plan was previously shared with Jane and Jeff, but I'm going to share the plan that our surveyors have been doing a little bit of work on to try to formalize this. And let's see, I do have the power. And oh, there we go. And so right now this is very much a draft, but this is a draft of our survey plans coming together. So we intend to essentially submit this survey plan of the boundary of the 28 Water Street property, and to take an area of 50-foot minimum width in the front of the property and designate that as subdivision road, which would remain the private road. And what we would be requesting is that the approved site plan essentially and the improvements that were proposed within the Water Street, the new Water Street right-of-way, be accepted as the proposed improvements for the subdivision road, and that any inconsistencies between this and the Holyoke subdivision regulations, we'd be requesting waivers in order to allow this site plan essentially to stand for the improvements that we want to make there.
And do you have a sense of when you would be actually submitting?
I think we were looking to, get clarity on procedure and whether, generally speaking, that concept of this property plan, including this segment of subdivision road, and improvements within that area as shown on the approved site plan, was going to be consistent with what the planning board is expecting for an approvable plan. And then once we do that, I imagine ESG is going to tell us to go ahead and get these plans finished up and get them submitted as soon as we can. So I think that's a matter of weeks at this point, because I think we've done a substantial portion of the survey work that's necessary in order to lock that in.
Well, I think that we just heard from our lawyer that this is something that we can accept. I am going to ask the rest of the board if they have questions or comments, and I will ask Jane to just reassure me that, yes, what I heard, or what I think I heard, was accurate. Jeff has his hand up, so he should jump in here.
Chris, can you please go back to the site plan? And where does that 50-foot line fall within the current proposed, where the right-of-way would be versus the existing?
Yes. And I am just realizing that we don't have that designated on here because these have been separate sets, but I can use my fancy PDF program to measure that out right now. So 50 feet is roughly there. So just to the roadside of the fence, it is inclusive of the parking spaces that we're showing there.
So what would be your proposal for that? Or even what are the three circles there?
The proposed plantings.
Those are plantings, okay.
Yep.
But what about any of the encroachments? How would you propose to get around that? Get around, not harsh word, or how would you propose to work around that?
Yeah, I think that what we'd be looking for is to consider that on-street parking on this private subdivision road serving 28 Water Street. And I suppose that's a question as to whether that whether there's a prohibition against that, or if that's a waivable condition if there is one.
And what would be the remaining passable way? 25 feet, I mean, what's the distance from the edge of improved way to the edge of the parking spaces, say?
Yeah, so that is, we're in the 23-foot range. I think it may get slightly narrower. I think we're somewhere around 20 in this area because we've got an obstruction that we had not been proposing to remove and is shared with the neighbor's property.
Well, obviously I'm not the city engineer. I just know that typically if there's parking in the right of way, it is public parking. But granted, this is a private way and private property, so it is kind of, it's a tricky one. But is the idea just to submit the plans, or is there actually further improvements? Is, you know, I mean, I know it's only what is it, 100 feet of how do you want to say it, depth, the total lot width from north to south?
Correct, is, we have that here, somewhere around 100 feet. That's about right.
It is, okay.
Yep.
So is the intent just for the process of submitting this plan, or is the intent to further improve this way?
So the direction that we've been asked to proceed with this from the client is that the proposed site plan, the proposed access shown on the site plan through Water Street would be the improvements that would be constructed, and they were not proposing to change that unless there's unless the city requires an additional change, because now this is not just the site plan, but also a subdivision plan. And so I think that's one of the things that we wanted to get clarity with this sort of pre-application meeting. If that's going to be required, then that's something that we can incorporate into the plan. But I think our sense was that if this site access was adequate for the site plan, that's not really changing. The project is still to construct this addition to the building with the improvements that were proposed, that were providing access to the site, but that because of this procedural and zoning ordinance requirement, we're going through the step of formalizing this as a subdivision road and not just the driveway to this site.
Understood. Well, just, bearing in mind too, that originally when phase one was done, phase one kind of blossomed into something beyond the original proposal. So,
Understood.
Could it have been different? Maybe if it went through site plan, maybe it would have. So just, just for the board's sake and the new member's sake, that this may not have been the most ideal situation, but now is what we're dealing with. So in trying to make this work. The subdivision process, we've probably done 6 subdivisions in 30 years. It's kind of a rusty process. I think the document itself is from like 1973, last amended around 82. To add multifamily for section 5. So it's, it's kind of an archaic document. I'm not sure how much you looked at it. I'm assuming you've seen some of the waivers, or you're aware of some of the waivers that you'll be requesting.
Yes.
Like sidewalks and stuff, stuff like that. I think there might even have been fire alarm call boxes, I think is a requirement in the document, which these days isn't really done. So anyways, you're looking at least with the submission, you're probably looking at, because the constraints of 48 and requirements for advertising up front, you're already looking at probably 3 to 4 weeks before it gets on an agenda, and then another meeting or so. So you're probably looking at a minimum of 6 to 8 weeks, perhaps, before a closure. Now I do recall, and again, please bear with me because it's rusty, because we've only done probably 6 and 30 years. I think there's an option of going right to definitive, or there's an option to start with a preliminary. I think if you fast track it to the definitive, means that if in the event it was denied, you wouldn't have the ability to go back for I forget if it's a time period or what, but I've got to get back into that mindset. But is this something that you would be looking to go directly to definitive, or is this one that you're gonna walk through the process as it's outlined?
So to respond to the first piece, I think that timeline is not terribly concerning for us. Construction, which was hoped to have started last fall, is still not initiated yet. It's at least a 6 to 8 month construction period, and our obligation is, and the ESG is fully aware, as was discussed at length at the planning board, that they're entirely at risk on that, and that this subdivision acceptance is going to be necessary to get a C of O, but we're looking at, looking for that C of O at least 6 to 8 months from now. So time-wise, that's a non-issue. I guess, the only thing that we would want to be cognizant of, if we did go straight to definitive, the only thing that we're at that point missing out on is the opportunity to get a formal comment and reaction on the plan. But typically with any kind of planning board process, there are always comments and revisions. So as long as there were still the opportunity to work with the board, I think we'd probably look to go straight to definitive, unless we were running some risk by doing that, that we could end up in a situation where we've got a plan that the board's not happy with, but there's limited opportunity to adjust it.
Right, gotcha. So I mean, so you're probably, in that case, you're probably better off starting with the preliminary and going through the process than just as a fail-safe, so that going right to definitive, again, we haven't, our new city engineer say he hasn't had an opportunity yet to see this. So it might be best then to take it through the full process, preliminary to definitive then.
That sounds appropriate. And then, presumably because we've got a much more developed plan than we'd typically come with preliminary, we'd use that opportunity for the comment process and revisions. And by the time we had an accepted preliminary subdivision, we'd probably have close to an approvable definitive, which would accelerate that process, I would think.
Gotcha. Yeah.
And I'll say this is an informal conversation, so that's all excellent input. Obviously, we'll talk back with the applicant and make a decision, but I'm thinking out loud just as their engineer.
So that all said, does anyone or does any member of the planning board want to comment on this? I see no one, and I would say it sounds as though, your lawyer and our lawyer have spoken to each other, and this is an approach that is worth pursuing. And, I think we are enthusiastic about getting it approved.
Great. And, what I didn't mention there in the discussion of, are these improvements adequate? I think something that we'll certainly highlight as part of this application process is this road and access have been here for well over 100 years. And this is a quirk of the zoning ordinance that we need to now formalize it. But I think there's no doubt that there's adequate access through this way. We're certainly going to be open to adjusting this plan however the board feels necessary in order to ensure the safe access through the site. But I think that that this is a well-established way that we're now putting onto a different piece of paper, but continuing to serve its function that it has for a long, long time.
Just while we've got you, was there ever any resolution with and I know we're kind of skipping topics a bit, but as far as some of the encroachments and whatnot with the property to the south, was there any resolution to that since we last?
I would have to ask if Leon is able to pop in and discuss that. I know some of the details, but I don't want to misspeak about exactly where that stood.
Yeah, good evening. Yes, there was a litany of items that Mark had submitted to the boards, and we checked them off one by one and completed it, with the exception of the hoods, which we will do during the construction period.
That being the hoods on the mechanical equipment here that extends over the line.
There was an encroachment there that we'll adjust when we do the construction.
What about the concrete of the pad?
Meaning the 6 inches that were over on this pad
Yeah.
down here, Leon. I mean, my memory is that Mark was willing to accept that encroachment. I don't know if that's been formalized anywhere, but that was not that was an item that was highlighted to ensure that it was exhaustive. But he was much more concerned about the hoods and the attachments to the lighting and those items.
Okay.
I'll have to revisit that with him, to be honest with you, because I don't remember. Yeah, I'll have to get in touch with him.
Thank you.
But on the other list, everything else that he had there was addressed.
Thank you.
Okay, are we all set for tonight?
I would just ask if Tom has any last details that we needed clarified, or if he thinks we're set.
No, I think we're all set. Thank you very much.
Okay, final call. Questions or comments from anybody? I see nothing, and we will see you back here in whatever time it takes with the next step in this process.
Very good. We'll
Yeah,
see you
thank
then.
you.
Thank you.
Thank you.
Okay, so is there anything else under project updates, old business, new business? There is nothing formally
I have
written on the agenda.
Nothing. Unless the board. Nope. Right, correct.
Then at this point, I would entertain a motion to enter into executive session to discuss topics relating to the proposed drive-through facility litigation over 500 East Hampton Road, Salma Realty.
So moved.
Second.
All in favor?
Roll call vote for Kate,
Yes.
Mimi,
Yes.
Rosanna,
Yes, ma'am.
Lauren,
Yes.
and Gardner.
Yes.
Okay, so if you have been joined us as a member of the public, we are going to kick you out of the meeting for the time being.
Mm. I think we're all set.
Okay, then I need the affirmations that we are all alone in our relative rooms and nobody can listen into this, which
Yes.
I am.
Yes.
Yes.
All alone.
Yes.
So, Jane, you are the leader for this, but in our last communication, I think we had the giant list from Mike Lavoie of proposed revised conditions, which I have been attempting to work through, and I'm still not sure I'm 100% on top of, but I'm sure everybody has comments, and I will let other people go first. Does anyone want to start?
Well, I did receive some written comments from Kate, so I have those.
Okay.
But that's the only person I heard from.
Yeah.
Yeah, and I don't feel the need to go through my written comments
Right.
orally. I
Yeah.
think Jane can take them and compile them with what other people think.
Okay, so in terms of sheer procedure, I will have written comments if we are carefully not comparing our notes. If we if talking about it now would be helpful, I can ask a few questions, but otherwise you will have written comments from me by some point tomorrow.
Yeah, I feel like we should talk about it.
Okay.
Just so I can kind of see, I mean, I have Kate's thoughts and ideas here, and questions. So if anybody else, I mean, mainly questions, concerns, that would be good. There were some questions that even, Mike Lavoy had, on the conditions, like, for example, the fire path apparatus. They say that they have obtained the approval of the fire department. I've reached out to them. I haven't heard back, the fire department. So I'm still essentially waiting on that. That one's kind of out there and outstanding. I mean, some general questions that I can find answers to pretty easily. But essentially what Mike Lavoy tried to do within the document that you see is he kind of mirrored our blanket number 1, right, on that first page, by putting a revised condition in there, essentially including all of our concerns, just kind of within that one little comment.
Yeah, I
Which,
liked that.
Yeah, which I thought was fine. So there's some where he removed, oh gosh, that made me blurry. There were some that he removed because it would be inclusive in that comment now.
Yeah.
So you'll see kind of notes under there, see revised condition number 1, see revised condition number 1. The reasons that those are already gone. So I think for the most part, yeah, he kind of just turned it into more of a blanket thing that they need to comply with, as opposed to everything being so specific.
Yeah, basically, it read to me as all of the specific things were things that they had not submitted as part of a real site plan because they refused to do a real site plan. And we're catching them all up by saying, hello, now you have to do the site plan that you promised us. And we are still
Right.
going to have to review it, presumably, and make sure that they've actually covered everything and we don't have a problem with it. And I was a little concerned about that because, you know, I don't know whether we are saying that they must submit and we must approve. But I think submission implies that we get to review the damn thing.
Right.
And, you know, that took care of a lot of it, being specific, because we were trying to memorialize all of our complaints. And most of what was removed looked to me like it was either covered by the site plan submission requirement, the new number 1, or because the judge had specifically said, no, you do not get to oversee what other departments might do. So,
Right.
you know, all of the stuff that had gone in there basically so that there would be some stopgap against political pressure is now gone.
Right.
And,
Right.
you know, since the judge is going to take it out anyway, unless we need it for potential appeal, I don't have a problem with that. It is what it is.
I mean, I think, you know, I think in the end, again, we have April 11th, right, which is the site visit. So we'll still know more after then. But I think, you know, essentially is what he tried to encompass in this with the spirit of the judge's order.
Yeah.
Is that we have to let our city departments do what they need to do, right?
Yeah.
And have faith in them that they are going to be able to do what they need to do under the law, right? And their requirements, and make sure, and despite the fact that, like, obviously as a board, you know, the contentiousness of this, it has been very difficult. But we need to try to give some deference, right, to our staff. And I think that's kind of where he was coming from. That's where I think the judge honestly, like, is coming from. So I think that was the spirit and the intent, and I don't disagree with that, right? Like, we need to have and allow the professionals, right, the ability to go through the process and have the ability to say yes or no based upon what they have in their everyday, you know, practice and business within the city. So it was hard though, you know, it's hard when you've been dealing with such a difficult applicant for so long, right? We want to have some sort of, like, the planning board was just trying to protect essentially the city, right? Like, from, so,
But the
I
principle.
mean, that all
holds
makes sense.
true. And if the
Right.
judge is going to, you know, if that is what he's going to do, you know, the principle applies regardless. You know, it was a reasonable thing to do, I still think, but
Right.
if we can't do it, we can't do it. And again.
And I mean, in the end, right, we have, we have at least the backup to say we were forced in our hand, right? Like, and then you can, to the constituents, to the members of the community, you can say, we tried. And that's all you can really do, right?
Yeah, well, and there is just, these are all discussions in pursuit of settlement. So,
right,
assuming, and perhaps wrongly, that if this went south in some kind of horrible way and we were looking at grounds to appeal, we would not have given anything up.
Right, exactly, right.
So
this is not going to be any sort of law of the case or anything like that. This is all between parties and settlement.
Yeah, and you know, so basically, giving on that principle, like, the departments are independent and we do not control them, isn't something I have a problem with. I did start fretting when we got to the thing about stacking, because, you know, Mike basically cut back our concerns about stacking to only stacking resulting in property damage or bodily injury. And, you know, I feel bad about this because it was the single issue that the city council emphasized most heavily in their discussions. They did not want any stacking. And our original condition was written for no stacking.
So we can simply tell Mike no. Say we don't want to take that one out. That one was very important if and the city council record shows that, right? Like, so we can just say no to that. I think that's reasonable as long as we have the support there.
Jane.
Jeff.
So here's a question though, as the person who presumably will still be here to, not that you're going anywhere, but assuming I'm still here, that's when this gets
What are you
resolved,
saying?
is that when I see this though, this condition number 1, that's all encompassing. There's going to be if we're going to remove all the, like, you know, like for instance, I'm looking at number 7, it says remove, see revised condition number 1, just using that as an example. But how, if number 1 says before the building permit issues any, the building department rather issues any permit, the owner applicant must submit a major site plan, you know, section 10 zoning ordinances, all requirements agreed upon during the review phase, including discussions, comment letters, meetings, hearings, and correspondence between the owner and applicant. Any additional, like, that is so broad. As one of the people doing that final review for whatever, how am I to know if they've actually covered number 7? Because chances are they're not going to provide it, and it's going to be embroiled in this number 1, which just says all requirements based on review phase, discussions, comment letters, meetings. If it's not spelled out, as the person that's going to be checking the box, how am I going to know I mean, it seems like it's almost like a moving target, or it's an open target, or it's open season. I don't know how else to say that. It seems really difficult on the back end, if this gets approved in this format, that there's not the checkbox that can be provided, because it's now gonna be in this generic number 1. And
Right,
then going on
but
to, yeah, sorry.
that's okay. Isn't it not your responsibility to ensure that there's adequate water pressurization? Isn't that something Holyoke Water Works handles? And isn't that something that needs to be done as a part of their permitting?
Sure, I was just using that as an example. I could have picked.
No, but
any
so
of the
that's what
others
I'm
that-
saying is
Yeah.
that the reason why it's coming out is because, yes, they need to comply with our ordinances and our regulations and everything
Right.
like that, but that necessarily, we don't need to spell it. The judge is essentially saying you don't need to spell that out because it's another department's responsibility. They have to comply with it. They
Correct.
have to do whatever that department says.
Well, we
Sure.
also,
But I think
though,
actually,
I think
oh,
we have a cheat sheet because we will still have this internal document and our internal, copies of the original notice, which, it won't be applicable because we will not be in this scenario enforcing the parts that say we get to review what another department comes back with. But we will still have the cheat sheet that says, for instance, that they need to be aware of the fact that they're proposing a wall on top of a retaining wall, and this is how you measure it.
right, which we know that's another case where we've never seen the details for that.
Well, exactly.
So-
And that was where I had some comfort through the new number 1 saying you have to submit the whole site plan so that we can look
Right.
at that and see and tell them if, in fact, their retaining wall doesn't work.
But then like going into number 4, and again, I'm not sure if this was, I don't want to drag this out any more than it needs to. I guess we could also submit comments. I wasn't prepared to do that, but I certainly could or can. But like under number 4, where it would be normally what we would consider a standard condition has been removed. And that being that the site plan review decision must be recorded in a 20-day appeal period. Does this project not have to be recorded, or does it not have to be, is there still an appeal period on this or no?
That's required under statute because you're governed by a special permit. You're doing the same thing. So it doesn't need to be in there because it's already required under the statute.
Okay, so again, if this is not in that final thing, I still have to be cognizant that I need to make sure everything's recorded, even though we're not explicitly calling it out as we have in the past.
Well, if it's not recorded, right, like,
Yeah,
that's not to the city's fault or error, that's to their fault or error.
understood.
Like,
but
that,
right,
but so what what the judge is trying to do essentially is say to the city of Holyoke, you don't need all this because it's already required. And I get it. I know where it comes from. I know it comes from a good spot. I do. Like, so I'm not trying to say that it's not, but if we want to get to a point where we know these requirements are either under statute or in our ordinances already, or it's another departmental thing that's required under some various scope of the law in the line. Do we really want to continue to fight over having it as a condition when it's already a requirement, like regardless? Right? Like, we're
absolutely
spending
not.
legal fees
right,
on
right.
that, and that's something to be cognizant of.
Sure.
And I know it
So what
stinks,
you're
like,
saying
that's
is-
money, but
Oh, yeah. But so what you're saying is you and I are gonna be a team going through this then, eventually when this gets finally to a formal thing, and then before planning staff makes any decision on anything as far as checking a box, that the law department will be right next to planning staff to get that done.
well, what type
check
of
that
box do you think you need to check? Like, for a department doing something? Like, what,
Yeah.
maybe, I don't know the process that you go through after a site plan,
Right.
like during that process, like, I don't know.
Right.
Like,
Well,
what,
under normal circumstances, if I receive, like, I get receipts or documents that show that it's been recorded or something. But some of
Mhm.
these are like, because we know the history of this applicant, and eventually what they could construe as a completed document, what if we're in such conflict that it's not?
But like what type, give me an example. I need an example.
The
I'm an
well, I
example
mean,
person.
I mean, I was gonna say something as simple as the notice of decision being recorded, but then even say the wall and fence combination. You know, I mean, so if they don't provide that, what if, I mean, is this, and instead they just give us a stick figure drawing? I mean, I don't know, something that's not detailed. I mean, you've seen what we've gotten with this. So I
So
don't know, I can't even think of
who
a
would be
scenario.
who would be the one to be overseeing the wall and fence?
It would be this,
Like
it would
who
be
would,
starting with the planning staff to then later figure out if it's taller than X number of feet, a special permit is needed. And then
okay,
later
so
upon
that, but
building
wouldn't
it,
that be Davin in building, right, for for
No.
compliance?
I would say not.
Why?
Well, because
Why?
because that's the difficulty. If we're now, and I'm not, this is the difficulty in the world that planning staff is living in now, because now we have another person that hasn't been involved in this process, who's now involved in the process. And so what, then I guess I have to redefine what is planning staff's role, because this has been under our tutelage up to a year ago. I guess there's a complexity there. It almost seems like, or there's a redundancy either way. Because having having a zoning person when formerly planning staff was the zoning person is kind of difficult. And from the start, it was
But there should
difficult.
have, it should never have been on planning to do that, right? Like it should have, we should have always, but we didn't, right? We should have always had some sort of zoning compliance officer that can go out and see these things and say, you're not in compliance. That violates
Yeah,
our
but-
statute or our ordinance.
Sure, okay.
And that happens. I mean, right now, that just happened with that one corner lot, right? Like someone, he goes out and checks it, or someone complains or something like that, and it's an
Right.
enforcement officer, right? Like that's what they have.
Sure.
It should never, like, unfortunately, Jeff, that happened, you know,
but-
that they
but
put
I'm
that
not
it was
even-
on you.
But the thing is, I'm not even, but I'm saying even before that building permit is issued. And I
So,
guess I'm
okay.
probably not making my point well enough, so
Well,
I'm gonna
no.
drop it just because it's not worth it.
No, I just want to see whether there is a simple fix for this. The simple fix being, if we go back to revised condition 1, if we add a sentence or two somewhere to it saying that owner applicant must submit a major site plan that complies with, and must submit evidence that the plan actually complies with all material elements of the whole zoning ordinance.
Right. I mean, we can have some sort of sentence in there that says, you know,
Something
any,
that-
right.
Yeah.
Any item that the applicant believes is fully complied with, they should provide like evidentiary support for that, including like the reference in the ordinance or a statute or regulation, and their documentation for supporting that, right? I mean, that's not a bad thing.
Yeah, I mean, if we throw that in there, they still have to give you everything. And it's true that you will not have the handy checklist in this document, but it is also true that you can get to the same place by using the notes we already have on the project. Because you're not going to throw those out just because this is accepted, if it is accepted, which I have my doubts about.
Oh, totally. Me too, Mimi.
So to a certain extent, I think all of this is going to turn out to be academic, but we have to treat it as though it isn't.
I mean, in the end, we could go to trial and the judge could just wipe it all out. And at least we said we tried, right? And that's all that we
Right.
can do. And we can file an appeal and go forward with that process. But
Or there can be a monster storm on the mountain the day he comes out to look.
Couple weeks, 2 weeks.
2 weeks.
Yeah, the 11th
So
is
yeah.
like literally right there.
It is, yeah. And then the trial's 3 weeks later. So we'll know at some point in the next month and a half what is going on
Nothing
and
will
where we're
happen.
going.
This is a species of Dante's Inferno, and we are going to be living through this forever.
It's true. It's true, Mimi.
But anyway,
So yeah, if there's any other, I'll take Kate's comments. Mimi, if you have any, Rosanna, Lauren, Vernander, anybody has any other comments? Jeff, if you want to throw some at me, that would be great. The sooner the better. I'd like to get these back to him, to Mike, so that he can get a response back to or get these over to the other side.
well, as I said, I expect to send you more of them. I just need to reread a whole bunch of the fine print from like stacking down, because those are the meat of the thing.
Right. And so
And-
again, Mimi, I am not like opposed to telling Michael, no, we have to have that in there. That needs to be in there. Not opposed at all.
Okay, good to know. I was actually impressed with how little of that he messed with.
Yeah, a lot of that he knew was important
Yeah.
to the board. And it is important for safety, for public safety.
It is, and most of this was about public safety. Like 99.9% of it was about public safety, and the other part was about the city council didn't want to see any stacking.
Right.
So, okay, I will make it my business to get you written comments rather than holding everybody up while I point at language and snarl about it.
Perfect.
Is one more call. Does anyone else have anything they want to say about this tonight? I feel like this is the regular mini ranting hour. But okay, in that case, is there a motion to exit executive session?
So moved.
Second.
All in favor?
Roll call vote for Mimi,
Yes.
Kate,
Yes.
Rosanna,
Yes, ma'am.
Lauren,
Yep.
and Gurnder.
Yes.